Good morning, good afternoon, or good whenever you've decided to sit down and watch this. And welcome to the fourth session of our LP Research Workshop. Today we're going to be going over how to find case law, and we'll talk for a bit about how to know if you've found a good case. But before we do any of that, let's review really quick and try to remember what we did last time and reflect on the methods we learned to find relevant codified law. What methods do you guys remember? Now, instead of listening to the wind to hear y'all's responses, let's go through them together. So, the methods we can use to find relevant codified law. The first one is if we already have a citation, which is definitely the easiest way to find them, and extra points if you remembered that we can find those citations in our second step when we're looking at our secondary sources. Now, another method we can use is using the finding tools like the popular names table or the indexes of our codes. Even if we don't know what a statute is called in full, like its big long name, we can still find it when all we know is the popular name by using that table. And indexes are great because sometimes we'll have situations where the law is written in this funky, kind of pompous language, but we'll be able to use common terms in the index to get us exactly where we need to go. Now, if neither of those options work, we can always open up the table of contents of one of our statutes, one of our codes, and browse from there. While this can be really time consuming sometimes, it can be really helpful when you either don't know where to start or you have a vague idea and decide to try finding something more on point. And if nothing else, if none of those things work, we can always do some advanced searching. Now, the databases have these internal filtering systems that we can use to tell it exactly the kind of content that we want. And if we learn the language of that filtering system, we can find what we need easily without wasting time or money. Even if we don't know that filtering system language just yet, our databases have these really nice forms that'll help us build those searches with the terms and keywords that we came up with in step 1 of the research process. But enough of all that. How do these methods actually help us make sure that a statute is relevant to our issue? Now, this is where the analysis is taking place. This is what we're training you for. If you're starting with a citation that you found in a secondary source, that means that you've already been analyzing the issue and you've already identified the thing that is relevant. And when it comes to the finding tools, you're already analyzing how related statutes are grouped and the language that they use, which ensures that you understand how it fits into the broader legal context. And then, when you're using advanced searching, you're refining your search based on the keywords or phrases you've been gathering from both step 1 and step 2 of the research process, which can help you focus on the statutes most relevant to the issue. Now, good job, everybody. We did it. We did great. And to celebrate our good job, let's move on. So I'm sure you're tired of hearing it as much as I'm tired of saying it, but I cannot stress enough how important it is for you to remember the 4-step legal research process. If you take nothing else from these workshops, I hope these 4 steps and these pretty little icons are seared into your brain and haunt your dreams for all time. So, we remember that the process starts with issue analysis, where we look at the facts and gather the who, where, when, etc. of the problem in front of us. This helps us identify the legal issue we're working with, and it helps us get acquainted with the nitty-gritty of our problem. Then we start looking into secondary sources so that we can learn the very broad strokes about the topic we're researching and start to get an idea of what law or laws and cases we need to look for. Then we get into codified law, where we look for what the actual letter of the law is. And then finally, we get into today's topic, case law precedent, where we look for cases so we can see how judges in the past have interpreted the law we found in the step we worked on previously. Lastly, I want you guys to remember that research is an iterative process, and that means that each new step further informs the last step you did, and your research will evolve while you're right in the middle of it. You might be deep in a secondary source before you realize that a particular fact you didn't notice at first is actually super important. And you might be already putting together your list of cases when you suddenly realize a case also relied on a new statutory law you hadn't even found yet. It will sometimes feel like your research is all over the place, but if you stick to the steps, it won't actually be as disorganized as you might feel. Got it? So last time we went over a bunch of different methods of locating relevant codified law. And in the same vein today, we're going to learn a bunch of different methods of locating relevant case law. So when we're researching case law, our ultimate goal is to find primary mandatory authority. We want to look for stuff that will bind the court before we look for stuff that will persuade the court. Because as much as we as lawyers like to think we are a naturally persuasive bunch, when it comes to presenting before a judge, that is not how it works. The court will for sure be bound by mandatory authority like statutes and regulations within our jurisdiction. That's a no-brainer. But cases will take a bit more of our analytical reasoning to determine if they're mandatory or persuasive. So in the preliminary analysis stage, in that issue analysis moment, we determined whether our issue is federal or state jurisdiction, and we took note of the geographic locations involved in our issue so we can determine whether cases will be mandatory or persuasive. So in the US, there are federal court systems and then completely separate state court systems, which I'm sure you guys already know. In general, opinions that come up from higher in the ladder of courts are binding on the lower courts in the same jurisdiction. So like the US Supreme Court decisions are binding on the US Courts of Appeal and the district courts. So if we had something like a federal issue at the district court level, the cases binding on our issue would be stuff from the district court in our jurisdiction, the circuit courts in our jurisdiction, and the US Supreme Court as a whole. I'll show you that Federal Circuit reporter map in a little bit though. But before we do that, let's talk about case reporter systems for a minute. This is, in essence, how cases are published in books called reporters. There's federal reporters, which house federal cases, and regional reporters, which house cases from specific regions. And of course, we can't just keep everything in one big giant book. That wouldn't make a lot of sense. No, there are actually different federal reporters for cases at different levels of the court's hierarchy. So the United States Reports houses U.S. Supreme Court cases, the Federal Reporter houses U.S. Court of Appeals cases, and the Federal Supplement houses U.S. District Court cases, and so on. And then the regional reporters house many states' cases. So like Texas's cases are housed in the Southwestern Reporter. Now, some states like California and New York have their own official state reporters, but like most other states, Texas doesn't do this. We just publish our stuff in the regional reporter along with all the Arkansas, Kentucky, Tennessee, and I think Missouri cases. So let's take a look really quick at the map. Okay, so here's that regional reporter map. So you can see that for our specific region, we are under the current reporter of Southwest 3rd, the Southwestern region, right? And we've got a bunch of different ones here, like the Southern region, which contains Alabama, Florida, Mississippi, etc. And then you notice that this one over here is so big. This is the Pacific one, and it's got all of these states. This is why some states have decided it's better to just publish their own state-specific reporter rather than rely on a regional reporter. They do still get published in the regional reporter, but because it is so large, sometimes they decide, like California, for instance, said, that's too much. Maybe we'll just do a California one. Now let's move on and do a quick review on the anatomy of a citation. I'm sure you guys already learned this in LP, but it's helpful to review. Now it's all in order right there. After the names of the parties involved, the first number after the comma is the volume of the reporter it's published in. Sometimes these volumes can correspond to certain years, and other times these volumes correspond to like page count. But either way, it's telling you which volume to look in. The next string of letters and periods is the reporter name. This one here is the Southwestern 3rd. Now the 3rd is a little strange because normally you would think that's what the volume is, but it's not. It's actually the addition. Sometimes we've been publishing cases so long that we just have to start the book over from scratch. Hence the 3rd. The next number we see is the first page of the case. A lot of times we call this a pin site. We are basically putting a pin in the exact location in the book where we can find that case. And lastly, we usually have the state and the year. Now, some reporters only have the year without referencing a state, especially when they only correspond to one specific court. So, like the US Supreme Court. In those situations, they will have the entire citation as is here, but then only have the year. But anyway, let's move on. So finally, we get to talk about how we can find these cases. Now, you can find a case pretty easily in the databases if you already have the case citation, right? And that can happen sometimes. Like maybe when you're working in a specific area of law, it'll be possible that your supervisor already knows that a case on your issue exists and will just give you the citation. Or maybe you were looking at a different case and found it cited within. Or like when we research codified law, maybe you saw it in a secondary source or within the annotations of a statute. There's tons of ways you might obtain the citation of a case, and when that happens, you can just plug it into the magic search bar and go straight to it. You can also look for a case by party name. Just like I said earlier, sometimes you'll find that your supervisor or something already knows that a case exists, but doesn't have the full citation, just the name. In situations like that, what you'll want to do is narrow as far as you can before you type in the magic search bar. So make sure you're already within the correct jurisdiction, within the current time period, and then you can search for the party names. And if we're starting from absolute scratch, we can always try the advanced search function to narrow down exactly what kind of case we need. And I didn't skip one. The last method I want to go over with y'all is the thing we call the one good case method, which means nothing to you right now, but allow me to explain. Now, this is our favorite method of finding cases and additional information when you're in the fourth step of the legal research process. Basically, you spend the first part of your time finding one good case, meaning a case that adheres to the majority of your facts and at least goes over the same rules of law as the fact pattern you need it for. Once you've found that case, we use a whole bunch of different methods and tools to move from that one good case to more relevant cases for our purposes, or even towards more binding cases for our jurisdiction. This is when we really start to see citators as a tool for more than just validating that we're still looking at good law. We talked about these a little bit last time. Y'all remember when I brought up the flag system on Westlaw and Lexis? That same system that validates the law is connected to a whole web of other legal authorities. Now, from that first good case that we find, we can review the head notes, the key numbers, the table of authorities, or even the case's history to find additional relevant cases. But we got to go over what those tools even are to understand more clearly, yeah? So, when court opinions are published, they're published within their respective reporters in chronological order. And then attorney editors on Westlaw organize these opinions by subject and assign a topic and a key number to every legal issue and sub-issue. It's like an index for cases, and they're attached to the head notes the attorney editors also write. Now, head notes are basically summaries of the minutia of the case details, like the points of law discussed within a case. But key numbers serve as a cross-referencing tool. They allow us to find all cases that discuss similar legal issues by topic across many different cases. Unlike head notes, which are specific to a single case, key numbers classify legal issues pretty universally. This means that we can use the same key number to find relevant cases on the same topic in any jurisdiction. So let's say you found a really good case that you like, but it's outside of your jurisdiction or something. You can look at the head notes and see the topics associated, the key numbers assigned to those topics, and then click into the key number to find other cases. But now we know that head notes are basically summaries of a point of law and that they're useful when finding relevant cases, but we should not ever cite them. They are not a part of the original case opinion, and citing them will get you in trouble. So instead, just use them to jump to the part of the case you want to cite and to identify other relevant cases using their associated topics and key numbers. Also, be aware that while Lexis also has headnotes, Lexis is usually created their headnotes with AI, and they're mostly just taken straight from the case without really changing any of the language. Even so, don't cite them. I would always verify that just in case you wouldn't want to be caught citing the incorrect thing. As for the key number system on Westlaw, that's entirely proprietary to Westlaw. Lexis has a very similar, but in my opinion, less effective citator system, which I believe is just called topics. So here's what topics, key numbers, and headnotes look like on Westlaw. I'm willing to bet y'all have seen these before, at least a little bit in your research. So at this point in your law school careers, I'm also willing to bet y'all use the headnotes more as a summary of the cases and less as finding tools, which is totally fine. They're useful for that reason. But have y'all noticed that these headnotes are often written really kind of vaguely, without a lot of detail from the facts of the case? That's because they're really summarizing a point of law and using that summary across their entire web of cases to link similar cases together by this exact topic. That's why it says 33 cases that cite this headnote. The key numbers do that too, in a telescoping order from least to most specific subject heading. Headnotes focus on summarizing legal issues in a specific case, while key numbers classify legal principles across all cases. And here's what that citator system looks like on Lexis. Now, it's really similar, but in my opinion, it is a little bit less pretty. The same functions apply though. The headnotes summarize the points of law within a case, and specifically on Lexis, they're mostly written by AI, and the topics follow the same nesting subject heading method. Now, in order to find our one good case, like we said earlier, we can search via case citation, via party names, or we can always use advanced searching. Before you begin searching, you gotta narrow down to the most specific jurisdiction and type of material you are looking for. Like if you're looking for Texas state cases, you don't want to start by searching everything in the entire database, right? So you go into the Texas state cases menu from the home screen, which I'll show you in a little bit, and then open the advanced searching form from there. The advanced search forms look much the same on both Lexis and Westlaw, and you can find some extra connectors here in the sidebar if you need. Just remember when you're doing this kind of search, be very wary of AI answers, and always check what you find to make sure your query is as precise and concise as it can be. As with everything we search for on these databases, you will need to read through the results to make sure you're finding the correct answers. So once you find your one good case, or even after you've moved down the metaphorical line a bit, you'll want to make sure that your case is still good and can be relied upon, right? Just like we don't want to go to court relying on a case that's not in our jurisdiction, we don't want to go to court wielding a case that's completely out of date or has already been properly overturned. So we'll use that citator system we love so much to validate our case law. So let's go over all of that again. So just like when we went over these in the codified law lecture, I want y'all to remember that a red flag doesn't always mean the case is bad law and you shouldn't use it. There will always be more information on what that red flag means, like whether it was only superseded in one particular issue or whether it was distinguished in a specific way, etc., etc. And usually it'll lead you to the case that gave this case the red flag in the first place. So pay attention to the citators and don't write them off just because they are a scary color. I'll show you where to find this system on Westlaw. And I'll show you where to find it on Lexis as well. The colors tend to mean mostly the same thing on Lexis as on Westlaw, at least when it comes to red and yellow. But even so, be sure to consult this little glossary when you run across a case with a scary little symbol on it. This is one of the few places I think Lexis is actually better than Westlaw because their symbols are particularly descriptive and more nuanced than what a simple red flag can convey. So when you see one, find out why it is there. Was the case superseded? Was it overturned? Was it done so in whole or in part? Does it actually apply to the issue that you're researching? Etc., etc., into perpetuity. You need to find out. But now that we've done all of that, let's get into the demo and the in-class exercise. I'll hop on Zoom and see you there. Okay, so the first thing I want to show you guys is that when court opinions are first published, they usually get published as an individual opinion, and this is called a slip opinion. So I wanted to show you really quick what that looks like. So I'm here on the Supreme Court website, and here is a couple of the slip opinions from 2024. So I'm just going to click this one so I can show you that it says like something like preliminary print. It will just kind of explain where it's going to be, but here it is. Here is the opinion as it first gets published, right? Cool. So let's get started with Westlaw. The first thing I want to show you is that we can do a search for a citation pretty easily. So I've got a citation pulled up over here. I'm going to look for Burke Royalty Co. versus Pace, and I've got the whole entire citation. So you just click that into the magic search bar, and it should take us exactly where we want to go. We just want to verify really quick. 620 Southwest 2nd, 882. Yep, and it says it right here. Here it is. Click on that. We got exactly where we needed to be. The same thing we can do on Lexis, where we can just put that in, open it up, no problem. And it'll take us straight to the case itself. A better way, an easier way to do this might be instead of just going from the magic search bar that is searching for everything in the database, everything at all, we could start with the cases database. Start by searching specifically within cases. That way, just in case something weird about the citation gets caught and it tries to give us something that isn't a case, we can mitigate that by doing it like this and using the filtering system like so. Now, let's say we only had party names, and let's hope that we only have very specific party names, very unique party names, because there's a whole bunch of US versus Smith, Smith versus Smith. You'll find a lot of those. So if we only have party names, let's hope that they're unique enough that we can make it work. Let's say specifically that our senior partner had mentioned an attractive nuisance case from 2005 involving East Texas Baptist University. So we only have a little bit of information, right? The first thing I would do, because I only have that single party name, would be to go to cases. And then from cases, from this cases database, I would open up the advanced searching menu. So we're not going to use this part up here first. We're not using this as a terms and connector search. What we're looking for is this bottom half, the document fields section, because in here is where we have the option to search for things based on where they exist in an opinion, like the party name, the digest it was in, the judge who opined, or the judge who created the concurring opinion or the dissenting opinion. We can do that. So here, I'm going to start typing East Texas Baptist University. Cool. And look at how it's creating that here in the search bar. See, it has that advanced moniker and then the TI because that's where I'm asking it for. It's for the party name, for the title. Okay, so let's look for that. We also know, like I said, that it's an attractive nuisance case from 2005. And that would be pretty difficult to figure out by just looking at this list of results. And we can see we've got a few too many results to sift through anyway. Not only do we have 10,000, we have an additional 4. That's when these filters come into play and these get really, really helpful. We know it was from 2005, so what we can do is we can look for a specific date range. And let's say I'm going to put from January 1st of 2005 to December 31st of 2005 because I'm not sure when in 2005. I just know it's in 2005. So we can run that search, and that helps us narrow it down a lot. But we also know what we're looking for is an attractive nuisance case. And look, we're doing great. We have 518 to sift through. That's much better than 10,000, but it's still not great. So the next thing we can do is use this search within results function. Now, this search within results function is excellent because you can just start searching for the terms and connectors that you would otherwise have to start with. However, it requires you to use some kind of like connectors language. So let's put it in quotations. How do you spell nuisance? That's how you spell nuisance. I'm putting it in quotations because that acts as one of the connector functions that will actually allow us to search within results properly. I'll explain that more when we get into terms and connectors next semester, but just keep that in mind. And look at that, just by knowing one of the parties' names, the year it came from, and the general idea of what I'm looking for, that I'm looking for attractive nuisance, we've narrowed it down to one case. This case right here, Woolridge versus East Texas Baptist. Cool. We can do the exact same thing on Lexis. And I'm not going to go through the whole process, but I want to show you really quick what it looks like. So under content, we would just open up the cases menu. And from the cases menu, we would go to the advanced search form. It looks much the same, except it gives us the document fields search bars above where the terms and connectors search bars are. Not like Westlaw where they had the terms and connectors one at the top and the document fields one at the bottom. But anyway, it would work exactly the same. We would put party name and then use the sidebar filters to narrow down from there. Okay, so now let's try to decipher topics, key numbers, head notes, all that kind of good stuff. So I have Woolridge versus East Texas Baptist up. And let's see if we can't find a head note that has something to do with property owners not being required to prevent injuries from naturally occurring things. So let's just say this is the case that I was given by my partner. I would have to read through the head notes first to figure out that numbers 5 and 6 have exactly what I'm looking for because these have something to do with preventing injuries and naturally occurring things, right? So let's look at the key numbers real quick. I want you guys to look over here and you see that not only does it have these numbers, but it also has the titles of what these numbers mean. For number 5 and 6, both of them have 272K1175. Both of them are things constituting attractive nuisances in general, right? This is our topic, this is our key number, and we got that from the head notes. So that's great. So real quick, I want to show you guys this. If you click onto a head note number, then it will take you down to that part in the case where they start talking about that head note, or I guess that they got the head note from. So, and if you click it again, it'll take you back up to the head notes. Okay, cool. We also have the option to look at the cases that cite the head note. Now, like I tried to explain earlier, it doesn't mean that a case actually cites the verbiage in the head note. It means that there is another case that has a similar, if not the exact same, head note. And if we click into it, we would see the next case. And then I really like this over here, this little depth meter. So this just basically tells you like how in depth this particular case gets into the legal question that was presented in that head note or the legal point that was presented in that head note. The higher the depth meter, the more analysis is actually taking place. Understandable. Also, I want you to note that this will also anticipate your jurisdiction. And one last point of order, I just want you to know that all of these topics and head notes are used the same across all jurisdictions in the US, right? So whether it's federal, whether it's state, these topics and key numbers will have all of those in common. So when you click into a key number, if you want a different jurisdiction, it will scour the entirety of the US to find that jurisdiction and it will scan every case in the database for this specific key number, no matter the jurisdiction. It works very similarly on Lexis. On Lexis, the head notes are a little bit further down, but here we have the string of topics, right? And it gets more nuanced as it goes down the line. So if we wanted to look for the same thing we were looking for back on Westlaw, we would find it here under Head Note 6. I would only find that because I was reading, but I had this prepared ahead of time. But you will have to read in order to know. But anyways, the string goes real property law, torts, nuisance, general overview, etc., etc. And if we were to click on this very last one, it kind of works the same as key numbers in that that is the most nuanced and detailed topic that we can actually look into. And if I were to click into it, it would also allow me to search all available jurisdictions. The same little head note trick works here too, where I can click the little head note button and it'll take me down to the point in the case where that head note is discussed. And if I click it again, it'll take me back to the top. Next, I want to show you how to keyword search. So let's say we didn't have any of the extra information that we had earlier, and we just knew we were looking for a case in the Texas state courts that had to do with attractive nuisance and that preferably defined the elements of attractive nuisance. So the way we would do that is the first thing is to set the jurisdiction to Texas state cases. So we would go to our cases database. And from here, we can filter down to Texas specifically. And then we could look at Texas state cases. We want to exclude the federal cases. From here, from this point, this is where we could open up the advanced search form. So we do that. And like I said, I want to look for attractive nuisance and the elements. So attractive nuisance is what we would call a term of art. So I would put that in quotation marks. And we have a section of this form that will do that for us. It would build the query for us like that. So here we would put attractive nuisance, making sure I spell it correctly. And then I also wanted to preferably define the elements. So that I could write up here in all of these terms. And you see how it's building this up here? It's building this query up here, doing the advanced elements and quotation marks attractive nuisance. From here, I could search. And I'm sure you already kind of know how to do this, but I want to just highlight all of these filters that we have here on the side. So not only could we continue to further filter by jurisdiction, we could filter by date, whether it's civil or criminal, the judge even. We could filter by a bunch of different things. And here's some new systems that we have using Westlaw's AI. We haven't really played with it very much, but I'm sure it works pretty okay if y'all want to play with it a little bit. I also want to show you that we can change this right here, this level of detail, in case we didn't have the time to open and read through every single case. We could give it the most detail in these search results. That way it would show us exactly where the terms that we looked for are popping up and whether they are involved in head notes and which head note for that matter. Now, this works almost exactly the same on Lexis, other than, the form being a little bit backwards. But other than that, if I ran the exact same search doing the exact same thing, I have the exact same types of filters. I can filter by the case type, by the court, by the timeline, etc., etc. And then I do also have the option to give it more detail than just the little bits that we're getting from the original search. Now, the last thing I want to show you guys, we're going to start back on Westlaw, but it's just how to validate your law. So here in the list of search results from the previous thing we were doing, I see a couple cases with some flags. So let's open up like this one. Let's open up this one that has a red flag on it because I want to show you that you don't just see the red flag and then immediately say no. it will actually tell you up here what is happening and why it was given a red flag, and it will link to the next thing. So, like this one, for instance, the judgment was completely reversed by Texas Utilities Electric Co. versus Timmons, and it tells you exactly when that took place. But we could click into it and then we would read it and figure out why the judgment was reversed. And it's very similar here on Lexus, just with the symbols instead, right? So let's do like this one that has a yellow square, or that's not a square, a yellow triangle. This yellow triangle, if we click onto it, it'll say caution, possible negative treatment is indicated. And if we click, it will give us the list of decisions that relate to this precariousness. And we can filter here by like analysis, by discussion, or even by court so that we can find exactly what we want. And if you ever need to find that key, it's right here in the little legend button, right here above the results. You click that little key and it'll tell you what these different symbols mean, the different depths of discussion, and a little bit more context for why those symbols are there. On Westlaw, if you ever need to find the list of the flags and what the flags mean, you would go to this little button that says powered by Keysight. It doesn't look like a button, but it is a button, and it will open up the legend so it'll actually tell you what those colored flags mean. But anyway, that's the demo. Let's do the in-class exercise. Okay, let's get through the in-class exercise. So, your client was injured in a drunk driving accident after a bar served alcohol to the driver despite his being visibly intoxicated. You're researching dram shop liability and are hoping to find some cases related to the obviously intoxicated element. So we're going to start with Westlaw. During your statutory research, you came across a case called Fay Corp versus Texas Alcoholic Beverage Commission in the notes of decisions. Pull up this case by party name, and we want to know which head note discusses the standard for obviously intoxicated. So we're going to have to pull up this case by party name, and we, at this moment, do not know the jurisdiction. So what we're going to do is we're just going to go to the cases database, and from the cases database, we're going to go to the advanced search. And then we can scroll down to the document field section and go to the party name and type in Fay Corp versus Texas Alcoholic Beverage Commission, and then run the search. We're lucky that this case has a very unique name. Hopefully, we won't get a whole bunch of results. We'll just get one or two that will have the case that we're looking for. And there it is, this very top one, Fay Corp versus Texas Alcoholic Beverage Commission. So let's open that up. We got to go read some head notes. We want to know which head note discusses the standard for obviously intoxicated. Now, normally what you would do is you would read to figure it out. But what I'm going to do right now, for the sake of time, is look for, whoops. I'm going to look for it with Control F and see what I can find. The first thing I see is Head Note 5, talking about how the server of alcoholic beverages is held to an objective standard of what a reasonably prudent person would have observed as obviously intoxicated. Cool. So that's the answer for number one, Head Note 5. Now we want to know what is the topic and key number associated with the head note that we found. So from here, we can see it is 23HK 1040 as to intoxicated or alcoholic consumers. Cool. Now we want to click on this key number and find out how many Texas state cases are there. So if I click into this, it will automatically assume my jurisdiction as Texas, state, and federal. But if I wanted to change that to only include state, I could do that. So I want to exclude the related federal and apply that. And I find that there are 12 cases. I can see from the results list there are 12 cases here. We want to know what the name of the most recent Supreme Court case is. Now, we could open up the jurisdiction panel here and look for the Supreme Court section, or we could just read, considering we don't have very many. But it's easier to do it this way. And if you have more, it'll be easier to do it this way. And we want to know the most recent Supreme Court case. We've got one from June 7th of 1890, and then we've got one from February 28th of 1997. I think this is the one we're looking for. Cool. That's the answers to number 3. For number 4, we want to return to the Fay Wray Corp case. So let's go back. Whoops. Let's go back. All the way back to the actual case itself. And we want to know how many cases cite it. So if we scroll up here, we can see we've got a tab here that says citing references. This is gonna amalgamate all of the places that this case gets cited, not just in things like secondary sources and maybe statutory materials, but in obviously other cases. So we could click into that, and we should click into that because we want to know if any of them discuss the issue related to Headnote 5. So of these 21 cases, we can look over here and find which ones have the same head note that we're looking for, which ones have head note 5, which is not many, I'll tell you now. Only 2 of them are going to discuss head note 5. But anyway, that's the Westlaw portion of our in-class exercise. Okay, the next part is on Lexis. So, question 5. When you're doing your secondary sources research in Dorsanio's Texas Lit Guide, you come across section 323.01 on the liability of commercial providers. Let's pull up the section. So, a little bit of review. Let's find that. So, we're going to go to content and we're going to go to secondary materials. We're going to go down to Texas. And then we're going to look for Dorsanio's Texas Lit Guide right here. And let's just browse real quick. We're looking for 323.01. That should be in here. And then in here. And then in here. And then in here. 323.01. Okay, we want to know what Texas Supreme Court case does this section cite to for the obviously intoxicated standard of care? Let's do a Control F and go to obviously intoxicated one more time. And when we read through it, we see that it is citing Smith versus Sewell. So let's open that up. That's the answer to number 5. For number 6, we want to navigate to the case, and we want to know which head note discusses the duty owed to the general public and the intoxicated customer not to serve alcohol when the licensee knows the patron is intoxicated. So let's go up to where the head notes are. That's a lot of words. So we want to know who owes the duty, and head note 1 tells us who owes the duty. The alcoholic beverage licensee owes the duty to all members of the general public. So cool. That's the answer to number 6. For number 7, we want to click on the blue HN box at left to move down to the part of the case associated with that head note. We click it. We want to know, to which case law authority does the court cite on the duty not to serve when they know the patron is intoxicated? So up here, we see the quote, and it cites Pastor. It just says Pastor because that's how, citations work. When we click into it, we see that it's Pastor, whoops, Go all the way back up. Pastor versus Champ's Restaurant. Cool. We want to go back, though, to the head note that we identified in the last question. So let's jump back out of that. Click the little head note button one more time. And we want to use a string of topics above the head note to find more cases on that topic. So how many Texas cases are there that include the phrase obviously intoxicated? So let's go to the most narrow that we can. And when you click it, it'll say get documents or create an alert. Hit get documents. And then from there, we can narrow by topic. From there, we can narrow to Texas courts only. Scroll all the way down, go to Texas courts. Then we can go back up to the search within results function and enter the search term, obviously intoxicated. And from here, we can see that we only have 54 cases to sift through. We could further filter this depending on what we needed, but we're doing great so far. That's the answer to number 8. So I'm going to let you guys do the reflection question by yourself. So let's do the next gen questions really quick. So your client was injured in a car accident caused by a drunk driver. In researching case law, you find a Texas Supreme Court decision addressing when a bar may be liable for over-serving alcohol. Which legal issue is most directly relevant to proving liability in this situation? Now, I can tell you already that it's not A, because whether the driver was of legal drinking age only matters in underage drinking cases. I can tell you it's not C, because whether the bar had policies or training in place does not control liability if the bar served an obviously intoxicated person. And it's not D, because whether the accident happened close in time and place to when the driver was last served may come up in causation arguments, but it is not part of the statutory standard. The answer is, in fact, B, whether the bar continued to serve the driver when it was apparent the driver was intoxicated, obviously intoxicated, to the point of posing a danger. And that's because liability turns on whether it was apparent to the provider that the patron was obviously intoxicated. So let's go to the next gen question number 2. Your client was injured in a car accident caused by a drunk driver who had been overserved at a bar. In 1 or 2 sentences, explain how Texas courts apply the obviously intoxicated standard when deciding whether a bar can be held liable. So, in order to answer this question, we not only need to have done our research, but we also need to have read through everything to understand what the standard of obvious intoxication is. A good answer for this kind of question would be something to the effect of Texas courts apply the obviously intoxicated standard by asking whether it was apparent to the alcohol provider that the driver was obviously intoxicated to the point of being a danger to themselves or others. And if this was apparent, that the bar may be held liable for the injuries caused by that driver. That's a long answer, even though it is only 2 sentences. That's a long answer, and it will require a lot of research. So I know that sometimes these next gen questions feel a little bit baby, but they're gonna get harder, and they're going to build off of each other as you take the test. So it will be worth it to practice these as we have them. But anyways, that's the end of the in-class exercise. Let's go back to the PowerPoint and finish up for today. So now that we're back at the PowerPoint, I just want to reiterate the 4 methods for finding cases. The first is if we already have a citation. Now we can get this if it's just given to us by a partner at our law firm, or if we find it in a secondary source, or we can even find it when we're researching codified law, right? We can find it in a bunch of different ways, but if we already have that citation, we can just plug it into the magic search bar and go from there, go straight to the case. Another way we can find cases is via party name. We might not even need the whole citation, especially if the party names are particularly unique. But when we have only the party names, what we want to do is we want to filter to the most narrow thing that we can. So we want to know what jurisdiction we're looking in, and we want to know what year we're looking in, etc. Then we can just use our party names and try to go from there. I cannot tell you how many Smith versus Smiths there are in the entirety of the databases, so make sure you're filtering. Another thing we can do is find one good case. Using the either methods above or just using our advanced searching, we can find a case that is really, really relevant and helpful to us, and then from there decide to find something using all of these citator tools that is more relevant to us via jurisdiction, via recency, all that kind of good stuff. And lastly, we can do some advanced searching to find something out of the blue if we really, really need to. We can use the form, or like we'll learn in some lectures next semester, we can learn how to build those searches on our own by learning the language of the filtering system of the databases. Study these up, guys. I want these steps burned into your retinas and etched into your brains. Really, really quick review. The 4-step legal research process. The first step is issue analysis. Who, what, where, when, pulling out keywords, pulling out terms of art. Step 2 is secondary sources. We look for the broader topic. We try to look for things that can help us understand. Then we start looking for codified law. We look for statutes and regulations, something that will give us an idea of what the law is trying to be. And then we look for case law that interprets what the codified law says and gives us a better understanding of how it is put into practice. Easy, very, very easy. This is the only thing I want you to remember for the rest of your life, and I really hope you do. And that is the end of our research workshop. Good job, we made it. If you have any questions or you need any research help on your way, you can always contact us in person, via email, via phone, or on our little live chat. We are always happy to help you out. Y'all have a great rest of your day. Be good and be safe, and I'll see you next time.